जस्टिस में है यूथ फॉर इक्वलिटी, इसमें लास्ट ऑर्डर सीट में काइंडली बी सी द पर्सनल प्रेजेंस ऑफ द रजिस्ट्रार and the registrar had not appeared before this honorable court. He filed the submission. He went to Ahmedabad.
ये रजिस्ट्रार नहीं आए अभी यहाँ पे?
My lord, currently, my lord, he's in Ahmedabad looking after his ailings.
Sorry?
He's in Ahmedabad, my lord.
Oh,
Person who's performing the duties of registrar, there is no regular registrar currently. In his, my lord, place, the OIC is present, my lord, in this court.
तो फिर हम वाइस चांसलर को बुलाते हैं।
My lord, the reply has been
वाइस
filed.
चांसलर तो है ना?
My lord,
Take note.
my lord, my request is
Why just
the
white
query.
order dated? Sorry, 20th January 2025. Registrar of the industry, number 3, was directed to pursue
In the year 2022, and now he's working in a different university, Guru Ghansidas University. And my lord, we were impleaded in this petition wide order 24.
Right.
So as soon as my lord, we have come to know, we have given
the respondent number 3 university. He was the representative of the petitioner. Filing of a writ petition invoking constitutional provisions before my lord is not a political activity at all. That cannot be regarded as a political activity of filing of a writ petition. Lord, in various matters, my lord has seen that this Youth for Equality was also a petitioner in Bihar where the petitions were allowed and the validity of the state legislation was objected to and it was declared ultra vires. Now, this objection cannot come from an intervener whose application for intervention is yet to be allowed. So he is not a party. He cannot move and claim any relief. Kindly see, my lord, his intervention application is IA 22706 of 20. He is not formally a party.
तो हम इस एप्लीकेशन को अलाउ करते हैं फिर?
जी, एप्लीकेशन
अलाउ करता है ठीक है।
And one more thing, my lord, before your lordship.
And also,
in view of the reasons stated in the state application, we hereby allow this in. Yes.
The second aspect is, Lord,
Right.
the objection which is orally put forth before your lordships is not part of IA 22260 of 2024. There is no objection on this point. My lord, we just have consideration of the IA number 22260 of 2024. And all these aspects are only orally stated before my lord. The objection there that a writ petition on a service matter as a PIL would not be maintainable, and they say, Lord, constitutional validity is to be presumed unless, Lord, it is declared ultra vires.
in this fact is mentioned in SIA, maintainability of.
नहीं, maintainability शब्द लिख देने से नहीं होगा.
And also mentioned the each person can not operate the political party during holding the post of professor.
My lord, just see the IM, Lord, the pleading.
And I have also filed the IA for clarification, the order dated 4/8/2023, my lord.
And I bring forward dismissal of the augmented.
Yes.
Yes. अगर इसको डिसमिस भी कर दे
जी,
तो इसी तो स्टिल पेंडिंग बिफोर द सुप्रीम कोर्ट।
नहीं, यदि ये डिसमिस हो जाएगी तो जो भर्ती है इस के अंतरिम आदेश के आधार पर जो रुकी हुई है वो भर्तियां क्लियर हो जाएंगी, क्योंकि इसी में आप देखें सर, जो कनेक्टेड पिटीशंस हैं WP एंड सीरियल नंबर 0.66 से लेकर के 69 तक के 5 पिटीशंस हैं। लगभग 250 कैंडिडेट्स हैं जो प्राइमरी टीचर की भर्ती से रिलेटेड हैं। इनको इसी केस में जो 4/8/2023 को अंतरिम आदेश पारित हुआ है उसके आधार पर इनको होल्ड कर दिया है रिट्रोस्पेक्टिव इफेक्ट से, जबकि अंतरिम आदेश हुआ है 2023 में, ये भर्ती है 2020 की। तो मेरा निवेदन सर ये है कि इनको सब्जेक्ट टू फाइनल आउटकम ऑफ द मेरिट पिटीशन which has already transferred।
और ये सुप्रीम कोर्ट चले जाएंगे सर?
नहीं सर, ऑर्डर सुप्रीम कोर्ट के ही आदेश के एक्सटेंट में मैं बोल रहा हूँ।
नहीं, सुप्रीम कोर्ट ने
The Supreme Court has specified my lord's refusal to vacate the interim stay. The same argument was advanced that it should be made subject to outcome. Presumption of validity is always there. Same argument was advanced. The Supreme Court of Anamika Tomar refused.
इसी केस में जो छत्तीसगढ़ वाला बेंच है उसी में सारे केस लिंक है।
but in this case which they have given, it is a stay, it is not subject to.
It is a stay.
It is stay only,
Which
not subject to. And this is regarding this state only, it is not some other petitions are there.
yes my lord,
This, the order which is given today in a number of these petitions are there. In this case, there is a stay. There
but
shall be stay of further proceeding in the writ petition number
so and so, but this petition is not included in this order।
Effect same रहेगा, उसमें कुछ नहीं होता। उसमें
my lord, this petition link along with the Chhattisgarh bench।
Despite the order passed by this court, the registrar of the respondent number 3 is not present in court. However, the said order was passed by this court because there was no representation from the respondent number 3. So today, counsel so appearing on respondent 3, and he has also filed the document on the court, and whereby it is stated that the writ petitioner, the writ petitioner political party, and that is signed by क्या नाम है इसका?
गिरीश कुमार सिंह
Girish Kumar
सिंह,
who being working in the
Secretary.
said university, could not participate in the political parties, and in the petition which is pending before this court is filed by the political party and signed by the person mentioned above, who was part of the university. Stop, admittedly, stop. No counsel for the petition submitted. The issue is not political. Therefore, any political party can file the petition. The fact is that it is not issue is not only political party. It is the issue that is filed by the person who was working in the university and simultaneously is the secretary of the political party. Secretary of the party, and as stated by the respondent 3, he could not have filed the present petition, being the secretary of the political party. Stop. But it is also stated by the respondent number 3 that the petitioner who has filed the petition already resigned from the university. Which year?
2022, my lord, he was relieved on date or by order dated 26/10/2022,
26
October 2022.
26 October 2022. Okay. So then, so now further intervention in view of our list after 4 weeks. But
My lord, मेरा एक निवेदन ये है,
just wait for
जिन केसेस में गवर्नमेंट ने फाइल नहीं किया है ट्रांसफर
हाँ ये
this petition may be dismissed on ground alone my lord।
उसका फायदा कुछ नहीं होगा ना।
नहीं होगा सर, फायदा होगा इसमें। नहीं, if this petition is dismissed, my lord,
I will place it before you. What he is saying, Lord, he wants disciplinary action to be taken against him by my employer. Regardless of that, Lord, my writ petitions, which is invoking constitutional provisions, cannot be dismissed on the ground, my Lord. There is no bar on a political party approaching my Lord. There has to be an express bar somewhere, my Lord, either in the constitution or in some judicial pronouncement.
Right.
Saying that, my Lord,
this petition, my lord, there is no constitutional validity of the impugned order. This is the completely administrative order, my lord. This petition is not challenging the constitutional validity of the Amendment Act. He have challenged the instruction issued by the GAD. Therefore, this petition may kindly be dismissed, my lord.
Just which one is that?
May kindly see, Lordship P1 और उसी पे स्टे हुआ है सर इसमें. P annex P2. P2 at page number 27, the instruction issued by GAD on 2nd September of 2021 अन्य पिछड़े वर्गों के लिए 27% आरक्षण के संबंध में मध्य प्रदेश लोक सेवा अनुसूचित जाति जनजाति आरक्षण अधिनियम.
Yes, you have challenged this one already.
yes, Lord, and I am invoking constitutional provision.
Now,
I am
where is
before my Lord.
Where is that? What is your prayer?
Lord, my
Come
prayer.
here.
I'll just explain, Lord, the factual
Yes,
background.
come to your prayer.
My Lord, I'll just explain the factual background. Lord. It says, Lord, what happened? My Lord was pleased to grant interim today, saying that in various other matters, Lord, saying that reservation for OBC community will remain at 14%, and the state will be permitted.
Prayer may I read, my lord, the prayer, my lord.
Prayer. Question.
This honorable court may plead to quash the satisfied the impugned order.
What is that impugned order is what I wanted to place before you.
121 P1.
Just consider what is that.
The amendment you have not challenged.
No.
Also challenge, that is also separate.
Where is?
वो petition दूसरी है इनकी.
No, in this case.
In this case, Lord, the challenge is limited only to.
दो petition है इनकी.
तो जो amendment है तो सुप्रीम कोर्ट गई.
नहीं, अमेंड सब दोनों.
आप इसकी बात करिए अपने.
मैं इसी की बात कर रहा हूँ.
हाँ, इसी में कहा है.
इसी में. इसमें जो prayer है, that is challenging a circular issued by the state government, saying that the interim orders would be applicable only to those cases where my lords have passed the order, and the state would be free to make appointment on the basis of 27%, regardless of my lord's order. In all other cases, my lord, they interpreted the my lord's order incorrectly. So I approached my lord's order, and my lord.
Miladi.
It is stated by the counsel for the intervener that this present political party has not challenged the amendment carried out by the legislation.
वो second petition है इनकी youth for equality की इसमें नहीं.
Challenge only the order dated 2nd September 2021 passed by response number 2. So since there is no the challenge to the amendment which established 27% reservation
Yes.
for the OBC. Therefore, the present petition is not maintainable. Same as
Lord, my lord,
It's
hear
all
me on
over.
that. My lord, kindly hear me on that.
Right.
बाकी जो आपका
No, my lord,
इशू आपका पेंडिंग
No, Lord,
रिपोर्ट पहुंच ही गया है.
hear me on that. Ask the appropriate order.
Yes.
My lord, hear me.
Yes.
No, my lord, kindly consider.
Yes.
My first objection is, my lord, on the ground that the intervener, that the application for maintainability has been moved by an intervener who is not a party to the proceedings.
Yes.
His intervention application is only today allowed by
Right.
he, at the time when he moved the application for the objection, my lord, the intervention application was not allowed, my lord, at that time. Therefore, the application seeking dismissal of the petition was also not maintainable. That is my first objection. The second objection is that if your lordship see the application for dismissal of the petition, it does not contain this ground that the petitioner, the representative of the petitioner was an employee of the.
This is submission का कर दिया. We found a false in his submission.
एक
There is one.
बार consider.
नहीं, this fact incorrect, my lord. The OBC महासभा is already
एक
filed.
second. अभी इसकी सबमिशन नहीं है, अब हमारे ओपिनियन है.
मैं
Yes.
मैं अपनी बात रख लूं फिर आप सब
Yes, please.
Now, my lord, the third ground, that if your lordship see, my lord, that there is no bar of a political party filing a writ petition before the Honorable High Court. There is no bar. My friend's objection is that the conduct rule says that a person who is part of a political party cannot participate, or it would be a misconduct on his part, and he cannot participate in a political movement or a political activity. The filing of a writ petition before my court is not a political activity under any circumstances.
We haven't quoted that.
My lord,
We
just
said so.
and that there is no bar on the part of a political party approaching my lord. In the Article 370 matter, Lord, almost all the political parties were entertained by the Honorable
So
Supreme
therefore,
Court.
you have not challenged the amendment, that's why we say so.
Lord,
After, if you challenge the
Lord,
amendment,
it is
yes,
not that
anybody
I
can.
challenge the constitutional validity that my writ petition might become maintainable.
That is-
Otherwise, my writ petition is.
It is not constitutional validity because for
Lord,
that
I am not
purpose you have to challenge that amendment.
Lord, I am saying.
By
Lord,
this
I am
order.
saying something else.
Right.
I am saying something else.
This is administrative.
Is it not the objection that if you only I challenge the constitutional validity of the amendment that the writ petition under Article 226 would be maintainable, and if I challenge an administrative order, the writ petition will not be maintainable. That cannot be an objection, Lord. Ultimately, in both cases, Article 226 is invoked, and I am invoking a constitutional provision. That invocation of the constitutional provision cannot be said to be a political activity under any circumstance.
So you can convert your transfer application into the SLP.
My lord, in my matter, my lord, which your lordships have
Second-
dealt with today, my lord, just bear with me for a moment. There is also a transfer application pending before the Honorable Supreme Court for this matter. Even for this matter, my lord, which challenges the administrative order, a transfer petition has been filed by the state government before the Honorable Supreme Court.
In which other petitions
My-
wherein the administrative order is challenged,
My-
which is the other petition the Supreme Court has entertained?
My lord, I am not aware.
No, no one,
Lord,
no
this
one,
is
no
for my-
one, no one. All petitions are related to the validity.
What I-
amendment. And second petition,
My friend was to point out
10/310.
the power of the employer to take disciplinary action against me for an alleged misconduct would result in dismissal of my writ petition.
No.
They are affecting
It is, listen, it is not that because even छोड़ो intermediate का छोड़ो, ये सारी हमारी तरफ से, that's all.
सर, एक बार
Intermediate की छोड़ दो,
एक बार कंसिडर इस एस्पेक्ट
हम intermediate की application भी जोड़
एक बार इस एस्पेक्ट
Our opinion is fine.
एक बार इनकी सारी बातें मान लीजिए
Yes.
कि मैं एक असिस्टेंट प्रोफेसर था, आई वाज वर्किंग and I was employed in a university and I could not participate in a political movement. This is not a political movement, my lord. They have not been able to justify, my lord, that my writ petition is a political movement. The second aspect is, my lord,
No, on
the
that
fact that
political movement वाला छोड़ के हमने simply ये है कि you have not challenged the amendment, right?
my lord, my challenge to the
Our
amendment is
limited.
separate, which is tagged along with this.
You have to challenge the only administrative
My
order.
lord, there is a
Therefore, we
challenge, there is a
say,
reason for the challenge.
therefore, it is not maintainable. We say.
My lord,
Anyway, Mr. Anshuman, sorry, we are not coming.
challenging the
And
next,
next, next.
I know we just see the 4-8. I know we just see the 4-8 order.
And my lord, 20,
This answer.
120,
Decent interim order in my favor.
उतनी है, उतनी बहुत है.
सर एक बार उसको देख लो order जो मेरे
Next matter.
My lord, may I make a humble submission? My lord, in my petition, my lord, I have challenged that order, your lordship, of the 2nd of September 2021, your lordship, whereby on the legal opinion of the learned advocate general, it has been directed to provide 27% reservation, your lordship, in the recruitment process, your lordship. My lord, the petitioners are the candidates, your lordship, who has participated in the examination of the sub-engineer, your lordship. And in that case, your lordship, the interim was granted by the honorable court, your lordship, on 11th of March 2024, your lordship.
What you have challenged here?
My lord, regarding the providing of 27% of OBC reservation to in this sub-engineer examination, lordship.
No, you have challenged the amendment or challenged the administrative order?
This administrative order, your lordship. I have challenged, your lordship.
No, administrative. आपकी petition number बताइए. Petition number? Petition number बताओ आपने.
My lord, 4531, that is also been tagged with the transfer branches, your lordship.
No, tag that is different.
My lord.
Order is not there. Is there any order from the Supreme Court?
My lord,
Not
not yet, my lord.
Not yet.
My lord.
आपकी petition ये भी जाएगी, दोनों जाएगी.
My lord, may I submit, my lord?
happened, Your
I
Lordship.
wanted to withdraw some petitions, my lord.
बताओ कौन सी नंबर बताइए अपना
70.70, 22.70. मतलब in that
आप
advertisement,
कौन सी विड्रॉ कर रहे हैं आप
मैं सर बेटा कर रहा हूँ 0.30, 0.31, 0.65, सॉरी मिनट 65 नहीं 0.30 and 31, 30 and 31 and 29, 129, 29 से लेके 31,
29 to 31
हाँ 3 petitions.
My lord, I would like to withdraw, my lord, 22.28.
इसमें with liberty file
29, 30, 31.
okay that's all
My lord,
with liberty file
my lord, my prayer is, my lord,
आप
20,
बताइए
my lord, one petition is 22.28.
sorry
22.28. I would like to withdraw this writ petition, my lord.
If he wants not, then he can make a prayer before the Honorable Supreme Court for withdrawal.
तो मिला टाइम
नहीं पर यहाँ यह विड्रॉ करेगा तो वहाँ भी बता देगा मैंने withdraw
We are just pointing out, Lord, because the Supreme Court said will not be further proceeding because the High Court stayed, Lord. This 22.2.
again this one okay leave it you are right leave it
My lord, the other petition is, my lord, is my lord, this is WP.
जितनी विड्रॉल वाली इनमें भी ऑर्डर है क्या सुप्रीम कोर्ट का इनमें नहीं जो बोलोगे ठीक है that's all.
Other petition is, my lord, 22.27. Here, my lord, there are total 11 petitioners, but out of the 11, 7 petitioners want to withdraw their names. They have filed this affidavit, my lord.
इनमें जो फाइल विड्रॉ कर रहे हैं इसमें स्टे हुआ है सुप्रीम कोर्ट से नहीं
To my knowledge, my lord, no
ये
stay.
लिख के दे दो जो भी है
This is the IA application, my lord. Only these petitioner will remain. Out of the 11, 7 wants to withdraw.
तीन का जो मिस्टर ठाकुर ने किया।
My lord, इसमें जो है 7
नहीं
0.27 में
आप क्या विड्रॉ कर रहे
My
हैं
lord, in this writ petition, total petitioners are 11. Out of them, 7 petitioners have filed an affidavit to withdraw their names from the,
petitioners in one petition
in one petition.
अच्छा वो कर दो
So petition will remain, but only these petitioners, 7 petitioners will be withdrawn.
District for these petitioners and petition is directed to file amended memo of parties within a week.
Obliged.
My lord, इस पिटीशन को जिसको विड्रा कर रहे हैं
Which one?
जिसको पिटिशनर 0.27 को विड्रा कर रहे हैं ढेर सारे पिटिशनर्स हैं तो शिक्षक वर्ग 1 वर्ग 2
Petition नहीं withdraw हुई, petitioners के
पिटिशनर्स के नाम विड्रा हुए my lord। लेकिन वो अलग अलग पिटिशनर हैं वर्ग 1 के हैं वर्ग 2 के और वर्ग 3 के अलग अलग शिक्षक हैं तो इसमें जो विड्रा करने मतलब इसमें पूरी जो शिक्षक की भर्ती इस पिटिशन की वजह से रुक गई है तो मतलब जिन पिटिशनर रिमेन है सिर्फ उनके संबंध में जो जैसे वर्ग 3 की अगर हो तो बचे रहे तो सिर्फ उनके भर्ती पर प्रभाव पड़ डाले बाकी अन्य जो पिटिशनर क्या करते हैं जैसे अगर वर्ग 1 वाले विड्रा कर ले रहे हैं वर्ग 1 वालों की भर्ती पर इसके एंट्री ऑर्डर का प्रभाव खत्म हो जाना चाहिए मेरा ये निवेदन है क्योंकि उनकी भर्ती वहां पर रोकी गई है सिर्फ इस पिटिशन की वजह से कि इनमें एंट्री ऑर्डर है तो इसमें अलग अलग भर्ती में 3 भर्तियों के पिटिशनर्स हैं
क्या चाहते हो उससे क्या
इसमें मैं चाहता हूँ माय लॉर्ड इसमें जो है इसके जो विड्रावल चाह रहे हैं माय लॉर्ड शिक्षक भर्ती वर्ग 1 और वर्ग 2 वाले वर्ग 3 वाले विड्रा कर रहे हैं वर्ग 2 वाले नहीं कर रहे हैं तो वर्ग 1 और वर्ग 2 पर से जो स्टे है वो माय लॉर्ड उसका प्रभाव खत्म हो जाना चाहिए इस पिटिशन का इंटीम ऑर्डर
ये petition इसकी है अगर ये withdraw करना चाहता हाउ कन्विंस हो
हम कन्विंस है माय लॉर्ड लेकिन इसमें कुछ पिटिशनर माय लॉर्ड विड्रा नहीं कर रहे हैं
तो कुछ नहीं यही तो बोला इसने कुछ कर रहे हैं सब नहीं कर रहे
तो इंटरिम ऑर्डर जो मतलब मैं चाहता हूँ उस हिसाब से मॉडिफाई किया जाए कि जो पिटिशनर हैं वो जिस रिक्वायरमेंट संबंधित है उस रिक्वायरमेंट पे उनका क्या कहते हैं कि इंटरिम ऑर्डर प्रभाव हो बाकी जो अपना विड्रा कर लिए हैं वो जिस अलग रिक्वायरमेंट संबंधित है भर्ती संबंधित है तो उस पे उनका प्रभाव जो है
My lord, I beg to differ from my learned friend, my lord, because as far as my relief clause is concerned, I have challenged the constitutional validity and that has been stayed. I have said it, my lord, in my relief clause that 27%, which was introduced on 24/12/2019, that I have challenged as ultra-virus and my lord have already granted the stay. So what my respectful, my friend is saying is I have not challenged only to quash. I have challenged, my lords have stated. So the writ petition remains, my lord, only 7 writ petitioners wants to withdraw their name because they have got the employment, my lord. My lord, hope highly obliged.
माय लॉर्ड इसमें जो इंटरिम ऑर्डर है माय लॉर्ड जिसकी वजह से हम प्रभावित हो रहे हैं ढेर सारे भर्तियां ऑर्डर डेटेड 18/11/2021 को देखा जाए माय लॉर्ड इसमें 18/11/2000 जो ऑर्डर है उसकी वजह से माय लॉर्ड जो टीचर की रिक्रूटमेंट है हाई स्कूल टीचर की मेलट वो सिर्फ इसमें अमेंडमेंट के तहत चला गया मेलट, लेकिन इसके द्वारा जो वर्ग 1 और वर्ग 3 के भी रिक्रूटमेंट को मेलट स्टिक किया जा रहा है। तो मैं चाहता हूँ मेलट इस हिसाब से इसमें जो पिटिशनर बच रहे हैं वो जिस रिक्रूटमेंट पर अलग अलग रिक्रूटमेंट के हैं, तो सिर्फ उस रिक्रूटमेंट के जिसके पिटिशनर रिमेन है, जो बचे रहे हैं, जो आगे चलाना चाहते हैं, तो उस रिक्रूटमेंट के क्या कहते हैं कि प्रभावित किया जाए। बाकी रिक्रूटमेंट को उसमें स्टे जो है 14 के अलावा 27% ओबीसी को दिया जाए। मेरा इतना निवेदन है।
So they can move an application and file a reply, what they are trying to say.
Just wait for that. Let's to go take the view.
Highly obliged.
Next one.
Highly obliged.
मेरा एक निवेदन और है।
तीन इन्होंने
वो विड्रॉ अलग है
हाँ
और फाइनल ऑर्डर
हाँ, 2 केस डिसमिस हो गया।
सीरियल नंबर 23
मेलट इसमें जो है 0.73 को गवर्नमेंट अगले डेट पे
अच्छा, नहीं 30
नहीं लास्ट 7 तो ये खाया अभी नहीं
Obliged.
सीरियल नंबर 23
But in this case, the petitioner was an elected sarpanch of the Gram Panchayat, and his election was challenged in election petition, which was allowed, and recount of vote was ordered. Election petitioner was an elected sarpanch of Gram Panchayat.
So the 3 years with us for the so this was the order one again, this is the administrative order and pursuant to the amendment. However, amendment is today, therefore not particular. Yes, please.
However, the petitioner was elected sarpanch of Gram Panchayat. His election was challenged in election petition, and recount of vote was directed by law. Now, that order of recount I have challenged on the ground of vagueness of pleading and non existence of evidence, my lord, apart from other reasons, my lord. Now, the writ court has recorded my submission, but in fact, my lord, all the issues which were raised in the petition has not been adjudicated, my lord, and all the condition has not been answered, my lord. Kindly have a perusal of para 4 of the impugn order, which is A1, where my contentions were recorded. May I read, my lord?
Para 4 years.
Para 4. As per the counsel of petitioner, the election petition does not contain specific pleading, and according to him, in para 9 and 10 of the election petition, there was no pleading made. Shri So has also submitted that evidence led by respondent number 2 and 3 were contrary to pleading, and in fact were based on hearsay evidence and also on surmises. He has submitted that in affidavit filed along with the election petition, it is stated that whatever averment made therein are based upon personal knowledge of election petitioner. However, the number of improperly rejected votes from polling booth number so-and-so has been reduced from 18 to 10 to 15 votes in evidence. The PW1 election petitioner has admitted that he was not present in the polling booth, and information with regard to rejection of 10-15 votes were conveyed by him by his counting agent. The counting agent Chandrasekhar Rai, PW2, has also admitted he was not present during the entire counting, and objection with respect to invalid rejection was made, whereas the procedure as contemplated under Rule 76 of Madhya Pradesh Panchayat Nirvachan Niyam 1995 was complied with. According to so-and-so, for the first time, objection was raised when the counting was at the verge of completion and only 30 votes were remaining to be counted. But in cross-examination of writ petitioner, he has stated that he left the counting hall before completion of counting. The counting agent Chandrasekhar Rai in examination chief itself has admitted that he has not actually seen the marking in rejected ballot paper, and as such the allegation about invalid rejection was neither supported with credible evidence nor substantiated in the evidence. He has further submitted that the pleading was not as per rule, and requirement regarding wrongful rejection of ballot based upon personal knowledge is not